what they do is they have, I think it's called a sound. It's basically a bay that they drag their nets through, and they try to catch all these shrimp. And in the process of doing that, whatever laws that they have on the books over there says that if you pull up this kind of fish or that kind of fish or whatever it is, that you have to release them back into the water. So as they're dragging their nets, they come up with these fish and they just toss them back in the water. Well, they got sued again by a radical environmental group that said that they're polluting, and the act of stirring up the sediment on the bottom pollutes the waterway, which is wildly absurd. But does it sound familiar, guys? Is basically they're stirring up sediment, kind of like a dredge, which is very short-lived, but it's something that's already in the water. You're not adding anything. So they got railroaded in the first court. They went to what's called the Fourth Circuit of Appeals, and they appealed that case to the Fourth Circuit. And the cool thing about this is it was a unanimous decision by the Fourth Circuit that no, this activity doesn't pollute, it doesn't add anything. So there's the key, is really that it doesn't add anything. So the thing that a lot of these courts rely on, guys, is what's called Chevron deference. And I want to put in here, hang on, I want to read what Chevron is. So Chevron is called the Loper-Bright case right now, and it was presented to the Supreme Court. This goes back, I think, I don't know, quite a few years. But basically, and I'll read their definition and we can talk about it. Chevron is a foundational case in administrative law, which the Supreme Court held, and this is a decision that the Supreme Court made a long time ago, that when a federal statute is ambiguous or silent, courts should defer to the agency's interpretation of that law so long as it's reasonable. We call that the fox guarding the henhouse, because if they're relying on the agency itself, the EPA, really to go, oh, well, we're the experts, so we're going to decide what's right and wrong, how is that fair? It's not. It should be that you can have outside third-party, non-political type of folks that evaluate that, or something other than having the one agency decide what's right and wrong, because they're always going to side for themselves. So that Chevron case was heard in January, and I'm quite confident, folks, that either Chevron's going to get overturned, meaning that they can't rely on the EPA experts' opinion anymore as a rule of law. They may overturn that entirely, or they may just remove certain portions of that. But either way, I think that that's going away. But we go back to the Fourth Circuit and the Ninth Circuit. So you got the shrimp trawlers here saying, hey, this activity, which is the same as dredging, doesn't pollute. And then you got the Ninth Circuit saying, yes, it does pollute. Now you've got Chevron, and they're all relying on the EPA basically to determine what the heck is law and not. Even though we don't add any of their pollutants listed under the Clean Water Act, is we have two courts that are completely opposed to one another. And the only resolution or remedy is to have the Supreme Court decide. That's where my case comes in, is it's really ripe for that. It's a legal term that they use. So anyway, last week it went through what's called conference, and that's where our case is actually presented to the Supreme Court. Now, there's basically three different ways that they could go. One, they could say, yes, we'll take the case, which is what we hope that they do. Two, they could say, no, we're not going to take the case, and then it's pretty much over. Or three, and it's a proposal that Pacific Legal had made to them, that they postponed this based on the Loper-Bright Chevron case, and then revisit. They could remand it back to the Ninth Circuit saying, hey, look, if we've done this stuff to Chevron, you guys need to take a second look at this. And so that's where we're at. And I would expect probably in the next, between a day and 2 weeks, we are going to know exactly what the Supreme Court's going to say as far as if they're going to take it, remand it, or whatever. So that's where we're at. This has been a long haul, guys. If the Supreme Court hears this case, this is big because it will likely result in waivers for suction dredging because they don't pollute as a matter of law. So that's why this case was so big. And I tell you, fighting this crap for 6 years takes a lot out of you. So anyway, there's your update. We'll let you know as soon as we hear something. See ya.